People's Lordship,
Yes.
my lord, I beg to mention item number 19.
1.
19.
Item 19. Yes.
Your Lordship, I was directed to appraise the district administration and Chief Engineer PWD. You know, as per the direction of the order dated 11/5.
Okay.
So partly I have received the instruction and partly I have not received. So Lordship, I may be allowed to file in the form of affidavit in the next step.
It's a report. You submit report. The direction is that the AG will take up the matter with the administration as well as the department and submit the report. So it will not be necessarily by way of an affidavit.
When can you submit?
By next date, if the court permits.
Okay.
Your Lordship, instead of waiting for another one, we can dispose the matter also today. We can make another.
The submission of the learned advocate general is that he has received some instructions, and then again, he is also going to get further instructions and wanted to file an affidavit. So let him file an affidavit in the form of an affidavit. I believe that will be more authentic for all of us to rely on such an affidavit. Even otherwise also, Lordships, two butthurt matters are there. All the councils are well equipped ahead of us. So in any case, also today, this item may not reach on time, Lordship. Otherwise, I am the appellant. I would like to press.
It is at the risk of the respondent. Delaying the matter, further delaying the matter may be in the interest of the appellant petitioners, but not in the interest of the respondent.
How can it be? Let my learned friend satisfy how the delay will benefit the appellant. We are the appellant. It is me who should press the case.
The longer the matter is delayed, now
How?
I'm
In
not
what
being
manner?
allowed to carry on with the works. That is the interest. They don't want
Is
to
the
do
work only within the appellant's village?
Yes,
Only within the appellant's village?
No.
only within the
No.
The entire stretch of the project is only within the
is
appellant's village?
completed. Yes, the others is completed.
Oh, other stretch completed,
Other stretch completed.
except
Around-
the land within the appellant's village.
Yes.
No,
Your
Lordship, there are two packages. One package already completed, that is beyond the jurisdiction of the
Outside
appellant's village.
jurisdiction of
And
Vista.
there are other areas also, which is not falling under within the jurisdiction of the appellants.
Those are completed. Only in this portion.
Okay, Mr. MT, you file your affidavit, but definitely by the next date.
And Your Lordship, in that case, let there be no further adjournment on the next date.
Mr. MT Imsong, the learned additional advocate general, submits that in terms of the order dated 12/5/2023, passed by this court, he is yet to receive the entire instructions from the respondents and therefore seeks for a week's time Prayer is allowed. Listed on. When is the next Wednesday?
21st. And Your Lordship, in the alternative, I may not be stopped from prosecuting the work.
Listed on 31/5/2023.
Liberty may be given to me for proceeding with the works.
It is made clear that there shall be no further adjournment of the case. Stop. The the submission of the respondent number
4.
4
Yes.
is that he has been restrained from executing the work by the appellant number,
Now, 1 is the RK construction.
by the appellant number 2
1
to,
to 80. 2 to 80.
by the appellant number
2
2 to 80 within the lane of their village jurisdiction.
Lord Chief,
Yes.
the same submission was made on the last occasion, and
Within
on the
the
basis
of
of
the
that
village
submission, Learned Additional Advocate General was directed to get instructions in
If
that
that,
regard.
if that be so, stop, if that be so. The appellant number 2 to 80 shall not obstruct the respondent number 4 from undertaking the construction in terms of the order passed by the learned single judge, since there is no stay to that order.
Lord
Listed
Chief,
on 31
my submission was that
5/2023.
we have never obstructed.
Okay, I have
That is-
recorded his
that is-
submission. If
is
that be
the
so,
submission only.
if that be so, please restrain yourself. Okay,
May I please, Lordship? Lordship, I beg to mention item number 2. Here, affidavit is ready. I'm waiting for the signature. So I pray that I'm given 3 weeks' time
you're
for the Union of India.
for,
For the Union of India.
and who's for the other respondents, state?
Lordship, I'm for respondent 3, 4, and 5.
Yeah, file your affidavit.
Lordship, we'll be filing, Lordship.
You'll be filing.
Lordship, 3, 4, and 5.
When?
3 weeks time will be granted, Lordship. In the meantime,
Mr. Yangarwati, you're for respondent number?
For the Union of India, 1. Respondent 1.
Mr. Yangarwati,
This is
the learned counsel for the respondent number 1. Who is for 2?
Lordship, respondent number 2,
they have filed.
they have filed their
They have
affidavit.
filed their
Lordship.
affidavit.
And Mr. V. Jamomi, the learned counsel for the respondent number 3, 4, and 5.
Lordship.
6 for 3 weeks' time for filing their affidavit in opposition, Prayer is allowed, listed after 3 weeks on a date to be fixed by the registry, okay?
Lordship, by order dated, Lordship, by order dated 22/2/23, respondent, learned government advocate has been directed to file comprehensive affidavit with regard to the functioning of State Food Security Commission, Lordship.
Lordship will be filing a comprehensive affidavit stating, since the prayer of the petitioner is to direct.
In terms of the order dated 22/2/2023, the affidavit in opposition filed by the state respondents shall be comprehensive.
Yes, Lordship.
Lordship, I also beg to mention item number 7. I have got a instruction to appear on behalf of the Union of India. So I may be given 3 weeks' time.
You're for?
The Union of India, respondent number 1.
Respondent one.
Done.
What about whether state is a government advocate? Yes, state is a party. 7. And Mr.
I'm
Moy,
representing 7, Lordship.
you're for?
7, Lordship.
7 is? 7 is?
NHIDCL, Lordship.
NHIDCL. And Mr. Beto?
Respondent number
2, 5.
5, 6, 8, 9, and 10.
Okay. Have you filed your affidavit?
No, Lordship.
What about Mr. Moa?
Lordship, I may be allowed 2 weeks, Lordship.
Okay. You,
2 weeks, Your Lordship. Seven.
Mr. Yangarwati, the learned CGC for the respondent number 1, comma, Mr. V. Jimomi, the learned counsel for the respondent number 2, the learned government advocate for the respondent number 2, 5, 6, 8, 9, and 10, and Mr. Moa Jamir, the learned counsel for the respondent number 7,
Lordship.
are allowed 3 weeks' time to file their affidavit in opposition,
May I please, Your Lordship?
listed accordingly.
Lordship, may I be for fixing a date, Lordship, since we are outstation council, Lordship.
Okay.
Can it be on 14th of June, Lordship? Up to your convenience, Lordship.
Yes, that's 3 weeks. Listed on? You actually cancel that line, huh? Listed on 3 weeks. You can list it on 14/6/2023. Okay?
Yes.
For
That's 3
admission
weeks.
column, Lordship, if so.
Yes.
For admission column, Lordship. Since the service has been completed.
Why admission column?
It's in the orders, Lordship. Since service has been completed, let it come under admission column.
Why was it listed in the order column?
On the last occasion, service was not completed, Lordship. That is why.
Okay. Listed in the admission column.
Much obliged.
May I please, Your Lordship?
Yes.
My lord, I beg to mention hearing item number 9 to 17. My lord, kindly let the matter be taken up after 2 weeks, my lord.
Why? This is in the hearing list.
Yes, my lord.
Why?
My lord, today I'm not prepared, my lord.
Adjournment is to be certain, they have to file some application or something, some form, no? From next time onwards, you file your adjournment slip. We come prepared, you seek for adjournment. Will not allow that. There is a direction from the principal seat, Chief Justice, that if you want adjournment, you have to actually mention it in the adjournment slip. So unless you fill up the adjournment slip, we may not be able to grant you any adjournment.
Next time.
Have you seen that notice?
Yes, my lord.
Then, let's see.
Again,
Let us see whether we can take up.
Okay, again, my lord, I beg to mention item number 4, 5, and 6. Here, I'm yet to receive instruction. In item number 4, WBC 222, of 2022, I'm appearing for respondent number 1 and
4,
1 and 3
4, 5,
and 6.
and 6. You are for?
Item number 4 here, I'm appearing for respondent number 1 and 3.
1 and 3 in item 4.
Yeah, Lordship, in item 4, I am appearing for respondent number 2, 4, and 5. I have filed my affidavit, Your Lordship.
Then 5,
Now, in 5 and 6, Your Lordship, actually, these are single bench matter. And I don't know why it was this.
Yes.
I am not appearing in 5 and 6.
My lord, here, item number 5 and 6, yes, it's a single bench matter, but it is related with item number 4, because in item number 5, pleadings is completed. Here, the whole stand of the state respondent is basing on Nagaland Police Manual Rule 33. And in item number 4, we have challenged this rule. Nagaland Police Manual, we have challenged that specific rule.
so in item 4, Mr. Tiba,
Yes, my lord.
you are for
1 and 3.
1 and
3.
1 and 3.
Yes.
Is it necessary for you to file affidavit?
My lord, since respondent number 2, 4, and 5 has filed affidavit, and that affidavit I've already sent to the respondent, whether they are going to rely.
I am asking you,
Yes. So
minus the affidavit filed by the respondent number 2, 4, and 5.
I'm yet to receive instruction, my lord.
Okay. Then what about the others?
In item number 6 also, the state is yet to file. Therefore, respondent number 1 to 3, the state is yet to file.
Item number 5, I have filed.
Item number 6.
6, I'm yet to file, my lord.
Item number 6,
I'm yet to file.
1 to 3, same.
No, item number 6. For all. 1, 2, and 3.
1, 2, and 3. Mr. Tibapong, the learned government advocate, submits that in item number, in WPC 222/2022, he is yet to file the affidavit in opposition on behalf of respondent number 1 and 3, and in WPC 237/2022 for the respondent number 1, 2, and 3, and therefore 6 for 2 weeks' time,
My lord, 3 weeks' time, my lord.
3 weeks' time. Prayer is allowed, listed after 3 weeks.
Much obliged.
For motion from supplementary list, IS single 39, 2023.
Yes.
May I please, Lordship? Lordship, sir, as per order dated 26/4/2023, this honorable
As
court,
per order dated 26/4.
26/4/2023, Lordship,
Yes,
this honorable court has directed for verification, spot verification of the building located at MP Road, Lordship. Lordship, in that regard, in compliance with order, in compliance with the order of this honorable court, the DMC, Lordship,
whether the status report has been filed?
Lordship, I may be allowed to place this letter, Lordship, letter dated 23.
Not yet, Lordship.
That is in accordance with this order.
Lordship, in compliance to the order of this
Okay.
honorable court,
Okay.
the DMC, the Dimapur Municipal Council, is going to carry out the verification only today at 12 p.m. Lordship. So I may be allowed to place this order.
When was this order passed?
On 26/4/2023, Lordship.
And why the verification only today?
Lordship, see,
Is the DMC such an important
no,
institution that
no,
it has
Lordship.
no time?
No, it's not that, Lordship. Lordship, the DMC that we have communicated personally also, the appellants and the respondents. But Lordship, in making the arrangements, everything, Lordship, takes time, Lordship. So only after this, Lordship, they have issued this letter, Lordship.
What is so difficult in just going and overseeing a small house, whether it has been dismantled or not, or whether it has been destroyed by natural calamities?
Yes, Lordship,
That's small shop.
very true, Lordship. But Lordship, this
You,
issue,
you are making a submission as if actually the shop, Linkwell shop, is a massive construction.
no, Lordship. Lordship, I appreciate that this case has been pending for quite a long time, Lordship, between the appellant and the respondent, Lordship. This issue has been carrying on for a long time, Lordship, and due to the seriousness, there's a serious claim and
Leave
counterclaim.
aside that. Leave aside that seriousness. That is to do with the merit.
Yes, Lordship.
This is to do with just an inspection of that small shop. The petitioner says that his shop roofing and all this, it has been destroyed by natural calamities.
Lordship.
You are actually like countering that, saying that it is the own work of the,
Yes, Lordship. On work of the appellant, Lordship.
and that is why actually the court, in order to ascertain whether actually what was the extent of damage, has ordered for verification. A small pawn shop, a small tailor shop. You are making a submission as if it is a multi-complex.
Lordship, since Lordship, may
Lordship,
kindly,
actually, to that effect, the Dimapur Municipal Council, Lordship, dated 20th March, Lordship, has has done the verification and issued me a certificate, Lordship.
Yes, all these certificates are being withdrawn because you have submitted false information.
No, Lordship,
Even
actually,
the Gaungura, he has withdrawn his certificate stating that you have submitted false information.
no, Lordship.
It was not destroyed by any natural calamity. You are actually, you are the person who has destroyed your building to reconstruct. And you are coming before this court saying that actually it was by natural calamity.
Well, actually, Lordship, actually, what has happened, Lordship? It was destroyed by natural calamities, by act of God. However, Lordship, on the basis of a false FIR, the Masjid Committee, Lordship, has tried to mislead this honorable court as well as the municipal council, so also the Gaubura, Lordship. However, the police personnel, the concerned OC, has already submitted his report stating that there is no false
Your
information.
next door neighbor has also filed an affidavit stating that it is you who has actually damaged the building to undertake construction. Your next door neighbor. They filed an affidavit.
Lordship,
You are the culprit. And
Lordship,
you are
those
coming
are-
before this court
Lordship, those are
as if you are the victim.
those are all, Lordship, afterthought, Lordship. However, Lordship, in the meantime, Lordship, this honorable court, his Lordship actually queried me that why this case, why this RFA is before the division bench, Lordship. And his Lordship was clear that it should have been before the single bench, Lordship. And Lordship, to that effect, Lordship, the Gauhati High Court rules, Lordship, if I may be allowed to go through, Lordship. Chapter 2, page 8, Lordship.
Who has filed this before this court?
Lordship,
Who has filed this? Who is the appellant
Lordship,
in the main case?
I'm the appellant.
And
Lordship.
why have you filed before this court?
Lordship, to that effect, Lordship, I was not the principal counsel, Lordship, and it was filed way back in the year 2011, Lordship. And as per 2011 amendment, Lordship, Chapter 2, Lordship, it says all regular first appeals, valuation of which exceeds 10 lakhs, may be heard by division bench. However, Lordship, as per the amendment of 2015, Lordship, it says that all civil appeals which are not required to be heard statutorily by a division bench may be heard by a learned single judge, irrespective of the valuation, Lordship.
Yes, so it has to be read in conjunction with the first provision.
Lordship. And however, Lordship, to that effect, Lordship, my senior, Mr. S. Datta, Lordship, he'll be available before this bench on Friday, Lordship.
Not on Friday. We have a division bench on Wednesday. Tell him to come on Wednesday.
Lordship.
This court cannot actually fix cases at the convenience of the lawyers.
Lordship.
Mr. Fusego,
Yes, Lordship.
how many days to verify that multi-complex?
Lordship, the DMC will be verifying today, Lordship, at 12, Lordship. So report will be ready by this evening. On the next day, we'll place it for his open court. It's a DMC, not the appellant or either the respondent, but the DMC. So, Lordship,
Mr. V. Debnath, the learned counsel for the applicant, and Mr. Fuseko, the learned counsel for
all the respondents, Lordship.
for all the opposite parties slash respondents. By the order dated 26/4/2023. The Gauhati and the administrator, Dimapur Municipal Council, was directed to physically verify the shop, namely MS Linkwell, and to make a note and status of the condition of the shop. Stop. Today, when the matter is listed, Mr. Fuseko, the learned counsel for the respondents, has placed the letter dated 22/5/2023, issued by the administrator, Dimapur Municipal Council, stating that the disputed side shall be jointly verified on 2/5/2023 at 12 a.m.
Lordship, 24/5.
Oh, 24/5/2023 at 12 a.m. Stop. In view of the letter issued by the administrator, DMC, Mr. Fuseko submits that the matter may be listed after a week so as to enable him to place the verification report, conduct the verification report of the administrator, Dimapur Municipal Council. Stop. Prayer is allowed. Listed on. When is the next? Listed on 31/5/2023. Stop. On the next date. Fixed. The verification report shall be placed without fail. Okay.
For admission, item 1, BIL 18/2020.
Your Lordship,
Yes,
I'm filing my additional affidavit during the course of the day, Your Lordship.
some development was there. No?
Yes, Your Lordship.
So what is, whether actually that development is in your favor or?
Yes, Your Lordship. In fact, somehow
Ah.
the state government has recognized the freedom fighters and the dependents by acknowledging a sum of 10 lakhs also. And in the meantime,
10 lakhs per head
no, Your Lordship, to the beneficiaries, Your Lordship.
to the beneficiaries,
Yes, Your Lordship.
cumulatively. Cumulatively.
Yes, Your Lordship. And what is happening is, at the moment, actual pay receipt is maintaining in a logbook, Your Lordship,
Okay,
under the
okay,
instruction of the Ministry of Home Affairs,
Okay.
where we are preparing a logistic data whereby entering the Aadhaar and then the thumb impression of the beneficiaries, Your Lordship. So that's why I have to take some time to file this additional affidavit, Your Lordship.
Okay. How much time?
Your Lordship, I'll be filing during the course of the day, Your Lordship.
Okay. So we listed again when?
Lordship. Next week, Your Lordship.
Okay.
If that's
After 2 weeks, I have the court choose affidavit and
Okay.
that instruction.
You're for union. MS Suntila, the learned counsel for the petitioner, submits that she may be allowed some time to file additional affidavit in the case. Prayer is allowed. Listed after 2 weeks. Okay.
much obliged.
Item 3, WPC 171/2022.
May I please, Your Lordship?
Yes, please.
My Lord, here, respondent number 1, 3, and 4 has filed their affidavit,
1, 3, and 4.
my Lord. However, respondent number 2, that is the Nagaland Public Service Commission, is yet to file, and they have not entered appearance also, my Lord. So I may be allowed to take fresh steps on respondent number 2.
Madam, you have filed your affidavit?
Yes, yes, Your Lordship.
Okay. Mr. Takakichu, the learned counsel for the petitioner, submits that he may be allowed to take fresh steps for service of notice upon respondent number
2,
2 by
registered post.
registered post with AD, as well as by usual process.
My Lord.
as well as by usual process within a period of
2 days, my lord.
2 days from the day. Prayer is allowed, listed up to 2 weeks.
My lord, in the meantime, the interim order passed earlier may be
Stop.
allowed.
The interim order passed earlier shall continue till the next returnable date.
Obliged, my lord.
For hearing, item 8, WPC 261, 2021.
Yes, Mr. Tongpok,
Yes, Your
you
Lordship.
want to continue?
Yes, Your Lordship. On the last stage, Your Lordship, direction was issued to the state respondents to file an additional affidavit on the nature of work performed by the two wings, Your Lordship.
Stating the
Yes.
nature of work performed by the.
Yes,
Yes, madam. You have filed.
yes.
Where is that affidavit? Additional affidavit as per the order dated 17/5. Yes. So have you gone through the affidavit?
I have gone through, Your Lordship, and there is no record in support of this affidavit. This is a mere declaration based on his own knowledge, Your Lordship. So now, Your Lordship,
This is an affidavit sworn
yes,
before this court.
sworn before this court, but Your Lordship, it must be supported by record. Now, I will produce those records, Your Lordship, before this honorable court. State records, Your Lordship, not mine. I'll show Your Lordships the records of the state as to whether it tallies with this or not, Your
You
Lordship.
bring it by way of an affidavit? Why?
If Your Lordship permits me, then I would like to bring it on record by way of an affidavit.
But what is that?
It's, Your
Is
Lordship,
it something very serious?
this has to do with rules of executive business. And the rules of executive business clearly lays down the nature of works to be performed by the two wings. It's very brief and it is clearly laid down, Your Lordship. And at the same time, they have also brought out annual administrative report. Here, the clear delineation is there, and it does not reflect the statements in this affidavit, Your Lordship.
So, Miss.
To be honest, Your
Madam,
Lordship.
is this affidavit on the basis of some records?
Yes, because Your Lordship, we follow because the department, it falls under the concurrent list, Lordship. So whatever instruction we get from the central also we follow. So we are following the manual, the National Employment Manual as well as the National Vocational Training Manual.
Your Lordship, I have also obtained a copy of the letter written by the director to the government with regard to bifurcation. Even in that, he has made it very clear that these are two separate wings brought together, and the functions has also been clearly delineated in that particular letter which has been written to the government. A reference has also been made about the executive rule of business. All these are there, Your Lordship. I have with me. If Your Lordship may allow me. For your lordship's satisfaction only, your lordship, if your lordship may want to go through it, and if necessary, I will file an affidavit. And even otherwise, your lordship, by way of this affidavit, it cannot supplement or explain away the service rules, your lordship. It has now become a question of law, your lordship, whether,
so
whether
whether,
by way of affidavit.
Service rules does not specifically state as to the nature of work performed by these two different.
Yes, your lordship, but giving that aside, your lordship, when the rules clearly lay out that these are two wings, and even though the word co-equal is not there, your lordship, it is implicit in the rule 3. The co-equality is implicit in the rule 3. But in the schedules.
What does Rule 3 says?
Rule 3 lays down that there will be two wings.
There will be
Yes,
two wings.
yes,
That's
two
all.
wings, and then joint director of one wing is there, joint director of another wing. So what is the difference between these two joint directors? For example, deputy directors, it goes on downwards. They have, in the two wings, equivalent posts are there. So now, if a distinction is to be drawn between them, how is it to be done? That is
why
one
we
question.
have sought for affidavit.
Your
We have
Lordship-
sought for affidavit from the
Yes,
government.
Your Lordship, but
asking them to explain
yes.
the different, the nature of work performed by these two different wings.
But the service rules itself should clearly give it, Your Lordship.
Service rule does not contain the nature of work performed by these two wings.
Your Lordship, then in that case, since I would not like to confront the court unnecessarily.
No, it's not a question of confrontation.
Yes, I'll
It's
give
a
your-
question of clarifying. We
Yes.
also want to let you assist the court.
I'll give
by
your,
clarifying the
yes,
facts.
yes. I'll just cite a Supreme Court decision where even an order passed must stand on its own, that it cannot be supplemented by way of affidavits. And service rules cannot be even
Say, Mr. Tombo,
amended by way of, yes.
let us see whether those citations will be relevant to your case, because actually.
Yes, Your Lordship. Your Lordship.
Because the service rule does not actually specify the nature of work.
Your Lordship, I'll take Your Lordship
And
to the.
if the government,
Yes, Your Lordship.
if actually the service rule does not specify the nature of work, and if the government,
Yes,
on the basis of certain concrete
Your
materials,
Lordship.
can satisfy this court that they perform this nature of work, the
Yes,
other perform
Your
this
Lordship.
nature of work,
Yes.
then in that case, I think there is nothing wrong in that.
Your Lordship, then allow me for your Lordship's satisfaction as to whether it is necessary to have these government records, which clearly shows the nature of works performed by the two wings.
You file your affidavit. You file your affidavit.
Your Lordship.
In terms of the order dated 17/5/2023. MSV Sokri, the additional AG, has filed an affidavit stating the nature of work performed by the employment wing and the craftsman wing. Stop. The statements projected in the affidavit is contested by Mr. Tongpok, Owner, the learned counsel for the petitioner, on the ground that the nature of work projected in the affidavit of the two wings is not based on any materials. Stop. Mr. Tongpok, the learned counsel for the petitioner, submits that he may be allowed to file an additional affidavit stating the nature of work performed by the employment wing and the training wing
Yes, craftsman training wing.
and the
Craftsman
craftsman
training wing.
training wing. in the Department of
It's a long Directorate of Nagaland Employment and Craftsman Training Services.
Nagaland Employment and
Craftsman Training Service. Your Lordship, I'll make it prefer. Directorate of Employment, Skill Development, and Entrepreneurship, Nagaland. Your Lordship.
the said affidavit shall be filed on or before on or before 29.
Your Lordship.
Okay,
Your Lordship.
on or before 29/5/2023, listed on 31/5/2023 for further hearing.
Item 9 to 17. Read Appeal 16, 2022.
Yes. Same case.
Yes, please, Your Lordship. The brief facts of the case is that the petitioner, they have served for 35 years.
You are the appellant.
Yes, my lord.
Ah.
Yes. So they have served for 35 years and released from the service without regularizing their service. So the petition, they approached the court by filing the writ petition number 241K of 2021.
Ah.
And that writ petition was disposed by order dated common judgment and order dated 24/3/2022. So my lord, here the appellant is aggrieved by order dated 24/3/2022. Lord, kindly see the page 52, Annex 3. Here, my lord, I'm aggrieved by para 5, page number 63.
63.
Yes, para 5 and 6.
No, but tell us first. Tell us the gist of the case. How many years the respondents have served the department?
35 years.
35.
Yes, on fixed pay.
All the respondents.
No,
The respondents in all these cases.
yes, one has served for 27 years and one 33 years.
Yes.
And the remaining 35 years.
One.
In writ appeal number 16 of 2022, the petitioner has served for 35 years and released from the service. And in writ appeal number 17, 2022, 33 years. Served for 33 years and released from the service. And writ appeal number 18, the petitioner has served for 35 years. 19, 35 years, 20, 30, 35 years, writ appeal number 21 of 2022, here 27 years.
What is your ground of appeal?
So my lord, here, I have two grounds. One is, in the state of Nagaland, there is only one office memorandum where the work charge employees can be regularized. So that office memorandum is dated 17 March 2015. And by this office memorandum, it says that those who have completed 30 years and enjoying scale of pay, the case will be considered. But in the instant rate appeal here, the petitioner, they are fixed pay. They are not enjoying scale of pay. That is why
So that gives you a right to use their service for 33, 35 years.
no one.
That is the issue.
So as per the office memorandum, the standing office memorandum, they are not eligible.
You have, Mister, you have used the service for 33, 35 years. The best part of their life you have utilized. And at the fag end of their career in service, you say you go empty-handed. Is it fair? Are you a model state? Are you a welfare state? What is the law of the laid down by the Supreme Court in regard to this? In regard to a person who has served for 33, 35 years. Not in a regular post. What is the law laid down by the Supreme Court? You are coming before this court in appeal.
Yes.
At least you need to satisfy this court with some legal grounds, not on your office memorandum.
That is
That
why
office memorandum totally goes against
yes.
the state as a welfare state. You actually satisfy this court with law points, with some citations, then we'll allow.
I'll ascertain that one.
Yeah. So give us that citations, because we are not actually we are not actually satisfied with the facts.
So my lord,
We
here
will only be satisfied if you can actually place some laws which says that despite the government utilizing the service of the respondents for 30, 35 years, you can send them empty-handed without any pinch.
and my lord, kindly allow me 2 weeks time so that I can place the
We'll give you 3 days time. Come back. Prepared.
next week then, my lord.
We'll give you 3 days. Because now I think the Kohima bench is filled up with these cases.
Yes.
So whatever, I think it's high time for us to dispose, and if anybody party is not aggrieved, is aggrieved, then they can always go somewhere. But actually, I think we have now multiple of cases of this nature. So it's high time for us also to dispose and let our judgment be scrutinized by the higher forums. That is what we are thinking. So you come prepared on this 31st,
Okay.
but tentatively you have known the mind of the court.
Yes.
Tentatively you have known the mind of the court. So come with something which can influence us to change our mind. Mr. E. Tibapon. For a short time to come prepared with the case for hearing. Listed on, prayer is allowed, listed on
31st.
31/5/2023. Okay.
Much obliged.
Item 18, read appeal 26, 2022.
Yes, Mr. TB,
May I please,
give us
Lordship?
the gist.
Yes. Lordship, the matter relates to regularization of work charge and grant of pensioner benefit, Your Lordship. Now, Lordship, I won't take much time. I will try to conclude within 45 minutes, Your Lordship. Now, just may I take Your Lordship to the facts, Your Lordship?
Yes, just give us the gist first.
Now, the case of the petitioner is that he was serving as work charge, and then he was upgraded like to semi-skilled level in the year 1987. Thereafter, Your Lordship, again he was promoted to the post of Chogita work charge, and after serving for 27 years, Your Lordship, in the year 2014, he was released from service. The case of the respondent petitioner before the Reed Court. Now, after his retirement, Your Lordship, he has submitted a representation 5 years after retirement. He has submitted representation praying for regular grant of pensioner benefit, Your Lordship. Now, during his service tenure, he has never submitted any representation for regularization or for payment of skill of pay. Skill of pay he did, but never
State of Gujarat and others versus Talsi Bhai Dhanji Bhai Patel. Dhanji Bhai Patel. This judgment has been reiterated again and again, and even in 2022.
Which judgment?
The loose judgment that I've placed, Lordship. In, Lordship, in the case of Prem Singh, 2019-10 SSC,
You're out of service
I'm out of service. Now, Lordship,
after serving for?
27 years. I retired on superannuation, not by length of service. Because Nagaland has got a peculiar system of retirement, Lordship. The only state in India which has got two systems. One is length of service and the other is superannuation. 60 or 35. So if I enter service lately, 35 might not affect me, but I'll be affected by 60 years. Lordship, this has been reiterated again in the case of Prem Singh in paragraph 31. Prem Singh, the paragraph 31, Lordship. Lordship, paragraph 31, Lordship. In the appropriate facts and circumstances, it was unfair on the part of the state government and its official to take work from the employees of the work charge on the work charge basis. They ought to have resorted to an appointment on a regular basis. The taking of work on the work charge basis for a long time amount to adopting the exploitative device. Later on, though their services has been regularized, however, the period spent by them in work charge establishment has not been counted towards the qualifying years service. Thus, they have not only been deprived of their due emolument during the period they serve on less salary in work charge establishment, but have also been deprived of counting of the period of pension benefits, as it is as if no service has been rendered by them. The state have been benefited by the service rendered by them in the heyday of their life on less salary in work charge establishment.
Okay, this is one aspect of the matter.
Yes. Because my case before the single bench was, Lordship, I have given my whole life in the service of the state.
Are you still alive?
Yes.
Okay.
And
Then in
God
that case-
forbid, during the pendency of this appeal, because he is already...
Let us hear Mr. TB, because actually let us see,
Lordship.
because single bench has already declared the OM 2015 as unconstitutional.
Yes, Lordship. And we are not denying it, Lordship, but that was not my case. I just made a mention about the.
And that is the case of the state.
Yes,
That is not your case.
yes,
But that is the case of the state.
that was the case.
State has stated that actually,
No, I am
like
not
in
covered-
terms of OM 2015, you have not completed 30 years of use.
Yes,
So you are not entitled.
yes.
So that is the case of the state.
But my case was, Lordship.
I know your case.
Yes.
I
Yes,
know
Lordship.
your case.
Yes, Lordship.
Your case is that you have now served for 30 years.
Yes,
Correct.
Lordship.
So you are in terms of the judgment passed by the Honorable Supreme Court, you are entitled to pension.
Yes,
That's all.
yes, Lordship. In
But,
fact, yes, Lordship has rightly pointed out, Lordship.
Let us see about the learned single judge declaring the scheme unconstitutional.
And though the word has been used as unconstitutional, but in the judgment, Lordship, if you Lordship may see, the single bench has not caution set aside the 15 OM. Lordship, may kindly see the order. It was just an observation on the part of the court. In the judgment, Lordship, no interference was made on the 15 OM. So they cannot say that it's redundant now. Single bench has not quashed and set aside the 15 OM, Lordship, because there was not a challenge in the single bench.
When a policy decision, Your Lordship, is declared as unconstitutional, whether any further order is
That can be
necessary
modified by this honorable court, Lordship.
to quash and set aside.
But it has not been quashed and set aside. No. And their contention is that in the writ appeal, that it's now redundant. But if you, Lordship, go for a clear reading of the judgment, 15 OM has not been touched. Court has just gone into my length of service. And in view of the judgment of this honorable court as well as of the apex court, Lordship, I'm entitled for pension. Because they have used my entire years of service.
Yes, Mr. TB, let us hear you.
Now, for the facts, just in brief, Your Lordship.
Yes, please.
May I take Your Lordship to page 28? Page 28 is a type copy, Your Lordship. Lordship has got it.
This is
This is the office order. Now, upgrading the petitioner from work charge level to work charge semi-level.
what is the first order of appointment?
The order of appointment, he has not, and the petitioner has not annexed it, Your Lordship. But then the fact of the matter is that he has served for 27 years.
Okay.
So to 2014, he has retired. So his date of entry into service will be what? 1987. So in the year he was appointed, the same year, Your Lordship, by this order, this is 21st July 1987. In the interest of public service, the following incumbents are hereby upgraded from work charge level to work charge semi-skill level, such and such. And the name of the petitioner appears as serial number 3. Lordship has got it. Now, may I take Your Lordship to page 30? Page 30, by this order, petitioner was promoted to the post of Chokidar. I'll be referring to one more annexure only.
Page 30.
Page 30. In the interest of public service, such and such is hereby promoted to the post of Chokidar in the scale of such and such plus such and such. Lordship has got it. Now, last annexure, Your Lordship, is page 36. So he was given the scale, Your Lordship, not that exploitation. You let someone work on work charge basis on fixed pay. Page 36. Page, Your Lordship. Release It's page 35. This is a release order, Your Lordship.
No, you were talking about the payment of scale.
Yes, Your Lordship, in page 30, that is promoted to the post of Chogita in the scale pay of such and such.
Just wait, just- Page 30, let me just.
So other cases may be
Just wait,
fixed pay,
just-
but he
just
was
wait.
given scale.
I wasn't fixed and I got a scale by
Lordship.
this order.
So from 1989, 87 he joined. From 2 years thereafter, he has been given scale of pay, Your Lordship. So it's not like other work charge employees who were made to work on fixed pay for years, and then let them go and retire, release from service empty-handed. Next, may I take Your Lordship to page 35. This is a release order. So by this order, 18/1/2014, Your Lordship, the petitioner was released from service. So first nature was upgradation, second is promotion, and third is the release order, Your Lordship. Thereafter, may I take Your Lordship to the next page, another last where petitioner submitted representation, Your Lordship.
36.
36. There the petitioner has given the
Just wait,
detail.
just wait.
Page 36 is a representation. Lordship has got it, page 36. This is the dated is nil, but bottom stamp is there. Date of receipt is 14/10/2019. So 5 years after his retirement, after he was released from service, he has submitted this representation. I will just read out the relevant paragraph, para 5. That I essentially served the department throughout my life, and it is my right to receive my pension benefit. In this regard, I approach your authority and also submitted representative to grant me. Yes, the representation is for pensioner benefit, Your Lordship. This was not considered, and therefore the petitioner has filed approached this honorable court by way of filing WPC number 215, WPC number 215 of 2021, Your Lordship. Which is at page 12 in the writ appeal. Page 12, WPC 215 of 2021. So praying for regularization and grant of pensioner benefit, Your Lordship.
Okay.
My Lord has got it. Lordships make out just the grounds taken for regularization and for pensioner benefit, Relevant paragraph 10 to 13. Let me read out these 4 paragraphs, Your Lordship.
In which, in your appeal or?
Yes,
in the
appeal. In the appeal memo, page 12 is the writ petition. I have annex. Page 12. And relevant portion, the grounds taken by the respondent
In
petition.
this writ petition?
Yes, Lordship. Page 20. Page 20 of the appeal memo, running page 20. In the writ petition, it will be page 6. Internal page 6.
Yes, wait, yes, wait,
Lordships, I got it.
yes, wait.
Paragraph 10. 10 to 13. Let me read out this.
Yes.
Paragraph 10 to 13. This is the case of the petitioner before the learned single judge.
Yes.
May I read out?
Yes, please.
Para 10. That the Central Service Pension Rules 1972 clearly lays down. I can skip it. Lordship may kindly from the 5th line from the bottom, relevant portion. This is Government of India order, top order number 1.
Which one were you reading?
Para 10, Your Lordship.
Yes.
Para 10, Rule 2, Your Lordship, has got third line application. Rule 2 application and Government of India's order in bold it is there.
Government of India's order. Correct.
So within bracket, one is there. This is the first Government of India order, Your Lordship. This Government of India orders is issued under Rule 2 of the CCS pension rules, Your Lordship.
Okay.
Now, it relates to grant of pensioner benefit to a temporary government servant retiring on superannuation, invalidation, or on completion of 20 years, now 10 years temporary service, Your Lordship. Now, relevant portion will be fifth line from the bottom.
Yes.
The question of grant of pension to government servants who retire after long years of service without being confirmed in any post has been under consideration for the government. It has been decided that a government servant who is in retirement from service on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority after he has rendered temporary service for not less than 20 years, now 10 years, shall be brought into the purview of CCS Pension Rules 1972, and the condition holding a pensionable post in a substantial capacity shall be dispensed with in this case. Your Lordship, Rule 2 of the CCS Pension Rules provides for application of the rules. Now, Rule 2 says that this will not be applied for those who are contingent employees, Your Lordship. So that has been dispensed with by this Government of India order. Consequently, such a government servant will be eligible for grant of superannuation or invalid pension, death cum retirement gratuity and family pension in accordance with the provision of the aforesaid rules. Now, next, this is the second Government of India order.
Number two.
Number 2. This government, the first Government of India order was issued in the year 1983, Your Lordship. And this second Government of India order is issued in the year 1987, issued on the recommendation of the 4th Central Pay Commission, Your Lordship.
Grant of pensionary benefits to temporary quasi?
Yes, temporary quasi-permanent government service.
Yes.
Now, number 2, terminal benefits. Quasi-permanent and temporary employees who retire on superannuation or on being declared permanently incapacitated for further government service for the appropriate medical authority after having rendered temporary service of not less than 10 years now shall be eligible for grant of superannuation invalid pension, retirement gratuity, and family pension at the same scale as admissible to the permanent employees under CCS Pension Rules 1977. Now, next page, Your Lordship. So, the case of the petitioner is that he is squarely covered by the said Government of India order, and as such, he is entitled for pension, pensioner benefit, and all other service benefit in view of the above standing orders of the Government of India order. So, this is the first ground taken by the respondent writ petitioner before the learned single judge, that he is covered by the Government of India order issued under Rule 2 of the CCS pension rules. First ground. The second ground taken is para 11. That moreover, the Government of Nagaland has also issued OM dated such and such, whereby a scheme for regularization and absorption of work charge employees has been framed. 12. That a bare perusal, Lordship want to rise, Lordship? Lordship want to rise?
Oh, yes. Just 2 minutes.
Lordship. So, Your Lordship,
Yes.
para 12. That a bare perusal of the office OM dated 17/3/2015 will show that the scheme will apply to those work charge employees who are enjoying scale pay with other conditions, and the case of the petitioner is squarely covered under the said scheme. However, in spite of the standing order of the Government of India and the scheme framed by the Government of Nagaland, the petitioner was deprived of his pensioner benefit. So the case of the petitioner, respondent petitioner before the learned single judge was that his case is covered by the CCS pension rules. Second is his case is also covered by the OM dated 17/3/2015, which relates to a scheme for regularization of work charge and casual employees, Your Lordship. And para 13, Your Lordship, this is the last paragraph. There is a third ground taken, Your Lordship. This Honorable Court in a similar case in such and such, by order dated such and such, has disposed the case with a direction to the state respondent to grant the petitioner with all pensioner benefit in accordance with the rules governing the service of the petitioner. The case of the petitioner in the instant case is similarly situated, Your Lordship. I will say these are totally different, facts are different. Next page. With the case of the petitioner in the above referred case, and such as such entitled to such pensioner benefit. Now, 15, Your Lordship, on the status, because the learned single judge has changed the status of the petitioner, that it is most respectfully submitted that petitioner was serving as work charge and was granted scale of pay, whatever. So by his own admission, Your Lordship, petitioner was serving as work charge till the time he was released from service, Your Lordship. Now, my submission, Your Lordship, my grounds, the grounds taken by the petitioner before the learned single judge, Your Lordship, is wrong, both in facts as well as in law, Your Lordship. Those three grounds. First, Your Lordship, both the order issued by the Government of India under Rule 2 of the CCS Pension Rules 1972, both the orders are not applicable, Your Lordship, to the petitioner. May I take Your Lordship to the CCS Pension Rules? I've given the list, Your Lordship, list of books. CCS Pension Rules. Rule 2, Your Lordship.
This application.
Rule 2, Your Lordship. Application and Rule 2,
Just wait, Mr. TD, just wait.
Rule 2. Rule 2 is like it provides for to whom this rule will apply. And I'll just refer to B and C.
Rule 2?
Rule 2 is the application.
Yes.
Save as otherwise provided in this rule, these rules shall apply to government servant appointed on such and such, including civilian government servant in the defense service appointed substantively, Your Lordship, to civil service and post in connection with the affair of the union, which are born on pensionable establishment, but shall not apply to B and C. Person in casual and daily rated employment, persons paid from contingencies, Your Lordship. Now, because work charge employees are paid on contingencies, Your Lordship. But this has been made exception, Your Lordship, relaxed by the Government of India order, Your Lordship, which I have read out. Order 1, order number 1.
Just wait.
Government of India order at the bottom, it is there, Your Lordship has got it.
Yeah. GIMF notification, 1st March 1972.
Lordship. So
where is this?
at the bottom in the CCS pension rules, Your Lordship, continuation, it will be there. Government of India order.
That's why we're Government of India's order.
One. Grant of pensioner benefit to temporary government servant, which was quoted by the petitioner, Your Lordship. Petitioner has quoted in the writ petition, which I have already read out.
This is Government of India's decision.
This is Government of India's order.
Decision.
Order. order issued under Rule 2 of the CCS pension rules. This is Government of India notification.
Government of India's decision.
Oh, here it is written order in my issue, Your Lordship. Anyway. Lordship. Okay. Anyway, decision order, whatever.
Order
Your
or
Lordship.
decision, okay?
Yeah.
Whichever convenient.
Lordship.
Order, just with order 1.
Order 1. So decision 1.
Okay, let us
Now-
read.
Now, I have read, petitioner has quoted in the writ petition which I have read out, Your Lordship. So may I just take Your Lordship to para 5? Para 5 of this order or decision. Para 5. Para 5.
Government of India's decision.
Para 5, Your Lordship.
Para 3, para 4.
Para 5.
Para 5 is?
The provision of this OM.
Just wait, we are not getting that.
Para 5.
We are referring to different books. What is actually the latest?
Lordship, I'm giving. But because there are only 2 orders, Government of India orders issued under Rule 2 of the CCS pension rule, which has been relied by the petitioner before the learned single judge and as reflected in the pleadings, Lordship, which I've read out.
This is Government of India's order 1.
May I take Your Lordship to para 5? Lordship has got it. Para 5, next page.
The Government of India's order, just wait. In terms of Rule 2. So this is where actually the problem lies for us, because actually this book does not have this. It has a different thing. So that's why we are saying Government of India's decision.
Lordship, this is Government of India order. This is so may I refer to my compilation, Your Lordship?
Yes.
May I refer to my
Yes,
compilation?
This compilation is from the book.
Yes, because CCS pension rules, Your Lordship, are titled because I don't know how. Because this is CCS pension rules. 1972, Your Lordship.
This is not. Government of pensionary benefits.
Even in the writ petition, Your Lordship, petitioner in the writ petition, para 10, Your Lordship, Government of India's order is there in the writ petition, page 6, which petitioner has quoted. Page 6, the writ petition.
Just
Page 6, in my appeal memo, it will be para 10, Your Lordship. Page 20 of the appeal memo.
whether the Government of India's order is reflected in this book,
No,
whether it will be reflected in the pension rules.
it has to be, Your Lordship. May I take Your Lordship to my appeal memo, page 20, para 10. This is part of the writ petition, and petitioner has quoted from here.
There must be some reference of this.
You see, government of, in terms of Rule 2, Oh, this is pension rules. Now 10 years.
This order which you are reading is 14487. This one. It's not there.
This is this. I think we need. Do you have the latest edition? What is the edition?
Yes. But here also
2017. Should be here. You bring this. No, it's all right, it's all right. You bring the latest edition. Swamis, no? You bring the latest edition. Swamis. Okay, anyhow, we will see.
If my lord may, can you refer to page 20 of my appeal memo? Petitioner has also quoted the same, your lordship. Page,
Memo.
page 20 of my appeal memo. Page 20.
Yes.
This is para 10 of the writ petition, your lordship. So the same has been quoted, your lordship. Rule 2 application, Government of India order.
So read.
Now, your lordship, may I take your lordship para 5 of the CCS rules? My compilation, your lordship may kindly refer to that. Para 5, your lordship. The provisions of this OM shall apply to those temporary government servants who are in service on 30/12/1980. That it is relevant, your lordship. Because by his own admission, petitioners entered service in the year 1987, because he retired in the year 2014 after serving for 27 years. So petitioner is not covered by this Government of India order.
Just wait.
Lordship got it? Oh, let's see.
That's all right. Government of India's order 1, no? This is 1.
Order number 1.
1 or
This is issued under Rule 2 of the CCS pension rules.
order 1. This is you are clause 5.
Clause 5, para 5, your lordship, para 5, which provides that provision of this OM shall apply to those temporary government servants who are in service as on 30/12/1980.
Okay.
Now, coming to the second order issued by the government of India,
Petitioner was appointed.
1987.
Yes.
Now, second OM, your lordship, second OM also, this is grant of pensioner benefit to temporary quasi-permanent government servant. May I take your lordship to para 5? para 5, Your Lordship. May I read out? The provisions of this OM shall apply to those temporary and quasi-permanent government servants who were in service as on 1/1/1986.
The provision of this office memorandum shall not apply to those temporary and casual government employees
1/1/1986.
who were in service on 1/1/1986.
So, Your Lordship.
So what is the provision of this, the office memorandum?
Now, Rule 2 of the CCS pension rules, Your Lordship, it says that this will apply only those to employees who are holding posts on substantive basis, Your Lordship. But by this order, Government of India's order, some relaxation has been made. Even those quasi-permanent or temporary employees who have served for more than 10 years. So some relaxation has been made for grant of pensionary benefit, Your Lordship. But in the present case, Your Lordship, the petitioner does not come even under that second notification. Your second notification cut-off date is 1/1/1986, when the petitioner was not even born.
Okay.
Therefore, Your Lordship, the ground taken by the petitioner that he is covered by Government of India's order issued under Rule 2 of the CCS Pension Rules 1972, it's wrong, Your Lordship. In fact, strictly speaking, Your Lordship, it is a misrepresentation. Because while petitioner has quoted para 1 and 2, the relevant portion, para 5, which provides for cut-off, that has not been reproduced here in the writ petition, Your Lordship. Not even annexed. Strictly speaking, Your Lordship, there is misrepresentation, Your Lordship, if I may be allowed to say so.
Yes.
Now, the second ground taken, Your Lordship, is that the opposite party petitioner is covered by the scheme, 2015 scheme, Your Lordship. May I take Your Lordship to the scheme, page 37 of the appeal memo?
This has become unconstitutional.
Lordship, no. In fact, petitioner has not challenged but relied on the scheme. But the learned single judge has held it to be unconstitutional. But petitioner has relied on this, that he is covered by this. Lordship. Page 37 is the scheme, Your Lordship. Page 37,
Page 37.
appeal memo.
Yes, with page 37.
Lordship has got it?
Yes.
Page 37, I will just read out the relevant paragraph, Your Lordship. Para 1, regularization in service,
Okay.
within bracket, Roman 1. All existing work charge and casual employees of various departments who are enjoying skill pay and who have completed 30 years or more continuous service as on 1/1/2015, Your Lordship. I would just, that is a relevant portion, 30 years.
30 years or more continuous service as on
1/1/2015.
So by
So-
1/1/2015, he
15.
or she should have completed 30 years.
by his own admission, Your Lordship, the petitioner was released from service after having served for 27 years. So in order to come within the purview of the scheme, Your Lordship, the petitioner has to satisfy this honorable court that he has served for 30 years on scale pay, Your Lordship. But this is not the case of the petitioner, Your Lordship. Therefore, the ground taken by the petitioner before the learned single judge, Your Lordship, is factually wrong, Your Lordship. Very good, Your Lordship. Now, Your Lordship, and the third ground taken by the opposite party petitioner before the writ court, that his case is covered by para 13 of the writ petition,
Para 13
13 by writ petition, which I read out, Your Lordship. Similar writ petition number 213 of 2012, and petitioner has annexed that judgment, Your Lordship, page 42, appeal memo. According to the petition before the learned single judge, his case is covered, squarely covered, similarly situated
by this.
by this, Your Lordship. Page 42, there is writ petition number 213,
Page
42. 42.
42.
Lordship has got it.
Yes.
This is WPC number 213K of 2012, Kurbuzo versus State of Nagaland. This order dated 8/7/2013. Now, the second paragraph, 11th paragraph, third paragraph. The brief facts necessary for disposal. Lordship has got it.
Yes.
Of the proceeding is that the petitioner was appointed as work charge Khalasi in the year 1980. So, Your Lordship, he is covered by the GOI notification under the establishment of SDU PHE Fusuro. Thereafter, he was again reinstated, appointed as work charge fitter, helper, by order dated 16/9/83 in the same establishment. While working as such, he was promoted to work charge fitter, grade 1, and was given special increment for sterilization operation. While in service, he was given scale pay, allowed to draw such and such, permitted to make deduction toward GPF, etc. What is more is that the service book was also maintained. In short, for all practical purposes, he was treated as regular employees. After working for more than 30 years in the work charge capacity, he retired from service with effect from 31/5/2012. So how can the opposite party or petitioner here can say that his case is similarly situated with the WPC 213 of 2012, Your Lordship? Appointment was 1980. In a way,
But when this order was passed, the scheme was not formulated then.
scheme was not formulated, right, 2013. But then, but even the facts, I'm on the facts, Your Lordship. More than 30 years he has this thing, and then at that time, GOI Government of India notification order was there, but that in a way it was applicable to him. But the petitioner cannot say that the similarly situated, the facts are same, Your Lordship. So therefore, the decision relied upon by the petitioner is not relevant at all, Your Lordship. Now, may I take Your Lordship to the order under challenge passed by the learned single judge, Your Lordship? What did the learned single judge say? Page 46, Your Lordship.
Page.
46.
Oh, this is judgment passed by Justice Ukato.
Lordship.
This is under challenge.
Lordship.
Oh, I thought it was by Justice, my Lord Justice Seto.
No.
I'm sorry.
May I read, Lordship?
Just wait, let me take down the page.
So this order dated 18/11/2012. Heard learned counsel for the petitioner and learned karma advocate such and such for the state respondent. The present rate is filed under section 226. It should be Article 226, Your Lordship, in issuance of such and such. Second part, learned counsel appearing for the petitioner submits that the petitioner herein was appointed as work charge employees in the Department of PHE, Peg Division during the 80s. He was upgraded to semi-skilled labor work charge on 21/7/1987 as per the order of the SDO PHE Peg Division under letter such and such. Thereafter, he was promoted to the post of Chowkidar by order dated such and such under letter number such and such. His service book, as in the practice, was opened thereafter, and he contributed to GPF and all other scheme as is practiced by required government servant. The petitioner was released on this by office order number this under letter number this. The petitioner was not given pensioner benefit as the respondent claimed that he is not a regular employee. The petitioner filed the writ petition before the Chief Engineer PHA Kohima,
How read petition?
The petitioner was not given pensioner benefit as the respondent claimed that he was not a regular employee.
The petitioner filed
Why?
writ petition before the chief engineer.
This should be representation. This should be representation, Your Worship.
Okay.
You are concerned with only the outcome of the order, not the content.
Okay.
Who is aired as person number 3 in the present writ petition for grant of pensioner benefit. However, although the same representation was finally received by respondent, there was no reply to the representation. Therefore, the present writ petition for grant of pensioner benefit to the petitioner. The learned counsel for the petitioner has relied upon the decision of this court in the case of which I referred to, Your Lordship, wherein the learned single judge has disposed of writ petition granting relief to the petitioner, relying upon this is 1987. After having considered that the petitioner had put in continuous uninterrupted service of 20 and 29 years, the coordinated bench of this court had directed that the respondent should regularize the service of the petitioner to grant him all pensioner benefit in accordance with law. Learned counsel submit that since the present facts and case of the petition is also covered, they are similar. That is what how it was projected. The same relief may be granted to the petitioner, but the facts are totally different, as I've shown you. Appearing for the state respondent 1, 2, and 3, Ms. Bichano Lerner submits that he has already received instruction and submit that this instruction was received that he was not covered under the scheme of the state government, not covered by the OM, Your Lordship. The above office OM provides for regularization and absorption of both charge and casual employees, revision of pay and wages. That covers only employees who have served for 30 years uninterrupted. The OM also requires that the employee should be on pay scale. It is the contention of the learned government advocate, Ms. Bichano, that the present petitioner, who has put in only 27 years of service, is not covered by the OM and is not eligible for any pensioner benefit as such. I have heard the submission made by the learned counsel for the petitioner and also the learned counsel for the state respondent. While examining the facts, it is seen that although the scheme dated such and such has been consistently presented as defense by the state government, the apex court has dealt with such nature of cases and has in no uncertain term pronounced that the state is a model employer and in a welfare state is not expected to exploit citizens in service matter. It has been decided over and again that when the state utilizes the service of employees for uninterrupted long years, then in such situation, the services of employees should be treated as regular employee and be entitled to all benefits of a regular government servant under the normal government service rules. Today, we are not hesitant to repeat that the rule of 30 years continuous service of scale pay as provided under the scheme is not workable, which is against the constitutional provision, specifically Article 14, 16, and 21. So it has been held that this scheme is unconstitutional. The petitioner here has put in 27 years of uninterrupted service. The state respondent should have made all effort in these long years of service either to regularize the service of the petitioner or discharge him at the time when the petitioner was fit to find other avocation to employ himself and sustain his livelihood. However, there is nothing shown on record that such efforts were made. In such a situation, we are unable to accept the contention that the petitioner was not on skill pay, nor had he completed 30 years of service. Actually, he was on skill pay, Your Worship. It may be pointed out here that, in fact, Your Lordship, it's so contrary to the record, he was given skill pay, Your Worship. It may be pointed out here that conditions that are laid out in such and such OM conditioning that the work charge employee should be on scale pay is devoid of any rationale since there is no rule or criteria laid out by the state government to which employee should be given scale pay and which employee should not be given scale. The learner single judge has had the notion that he was on fixed pay, not scale pay. As per this order, this sentence, Your Worship. Therefore, under this rule, a person who does not serve on scale pay would not be opportune to avail the scheme provided under this OM, even if he serves for decades. This court has repeatedly read out the same OM giving decision in line with several rulings of the apex court in cases of such nature. Despite the ban on work charge employees by the state respondent, OM, there is continued indulgence in issuing appointment under different terminologies such as contract, ad hoc, casual, temporary, work charge, fixed pay, etc. However, all these categories of appointments seems to refer to the same group of employees considering the utilization of these employees. Most of the time, this category of employees have claimed to have continuously served for more than 20 years without regularization and therefore disprivileged of pensionary benefit and other benefit enjoyed by regular government servant. This is when it takes the color of exploitation, compelling the court to take steps. In such a situation, where the state respondent continues to employ without open advertisement and utilize service of employees over a considerable period of time, the state is debarred from taking the plea that petitioner and not regular employees, petitioners are not regular employees, and disprivilege them from pensionary benefit. One cannot be allowed to take advantage of his own misdeed. For the purpose of the present writ petition, we have observed that the coordinate bench of this court has given relief to petitioner in several cases as illustrated and has already been referred by the learned counsel for the petitioner. However, it will be beneficial to bring out the observation and decision of the division bench of this court instead of Manipur such and such, of which relevant paragraph is reproduced below, Your Lordship. I'm not, because this is pre of Madibi, I'm not referring to it, Your Lordship. Even
No,
second,
read.
or just relevant portion, para 11, Your Lordship. We are being disturbed that the petitioner were compelled to go on superannuation after putting in 28 and 29 years of service respectively without any pensionary and other retail benefit. In a welfare state like ours, committed to a socialistic pattern of society, it is unconscionable that employers compel the employee to go on retirement without any retail benefits after putting 28 and 29 years of service on the pretext of contractual service, Your Lordship. So Article 14 is there on similar line, Your Lordship. So next page, this is a lengthy one, so let me just skip this 11th. Now, page 53, Your Lordship. After being above being the observation and decision of the division bench, this court is unable to give any interpretation but to endorse the decision and give relief to the petitioner. As per record, the petitioner was already completed more than 27 years of service as a contract employee, not contract, Your Worship. The status of work charge has been changed to a contract and superannuated. The contract appointment must be terminable at some stage of service. If the contract appointment continues until superannuation, the character of the appointment ultimately changes and the employee has to be treated under normal government service rules, entitling them to pensionary benefit. The state respondent, special respondent number 1, 2, and 3, shall take steps to regularize the service of the petitioner for the purpose of granting pensionary benefit to the petitioner as permissible under law. The steps should be completed within 2 months of the passing of this order. The petition is disposed, Your Lordship. Now,
Where has he discussed about this pension provision?
no, Your Lordship.
Not
No,
discussed.
not discussed, Your Lordship, regarding CCS pension rules.
Because
Nothing has been discussed,
the
Your
point was-
Lordship.
That was clarified in the court, Lordship. That was clarified.
clarified?
I'll come to that. Lordship.
No, just
Yes, listen. I just want to clear. I'll come to that.
come, Mr. TB. Whether any discussion was made?
Lordship, I was not before I did not appear before the learner single year, but nothing has been reflected in that.
Nothing, that's why.
Nothing has been reflected, Your Lordship. Whether Lordship.
And your claim before the single bench was that you are entitled to pension under
Yes.
the
Yes.
CCS pension rules, order 1 and 2.
Yes. Now, in the judgment that my learned friend has just read out, in WBC number 213, a certain observation has been made by the single bench, Lordship. Lordship, may kindly come to page 42.
Yeah, I'll come to you. Just wait. I'm still hearing the petitioner.
Yes.
The appealant.
So, Your Lordship, the grounds for challenge is that, firstly, as I've said, Your Lordship, petitioner is not covered by the order issued by the Government of India under Rule 2 of the CCS Pension Rules 1972. The second ground for challenge is that the petitioner is also not covered by the 2015 scheme for regularization of work charge and
On that, see, Mr. TV,
Lordship.
on that, the petitioner is not covered by the 2015.
15.
2015.
Yes, 17 March.
2000. There is a judgment, recent judgment of Justice Serto and Debashis. Do you have that, Justice?
Yes.
Do you have that? Let us see that copy. You didn't have this copy?
Lordship, no, I don't have.
Justice Alice Jami and Justice.
you're not-
No. The Justice Debashis, a very elaborate discussion has been made. Let's see.
I have the Justice.
No, not this.
But here also, regarding the
Your
Kohima
Lordship, my
15,
submission is mainly confined to, like, at the time when
No,
this.
your submission is actually on 3 grounds.
Yes.
That on 2 grounds primarily.
And then the third ground, because that decision is not applicable, facts are different, Your Lordship.
Yes.
Yeah, like what was there before the material available on record before the learner single judge at the time of passing of.
Firstly, your ground is that the petitioner, the respondent is not entitled to pensionary benefits under CCS pension rules, even reading order 1 and 2. Okay. Secondly, is that since the respondent has not completed 30 years of service, he is not entitled to the benefit of the scheme.
Lordship.
Correct.
And the third.
In that, that's what I'm saying. In that, because we don't want to contradict any order. In that, there is a very clear order of Justice Serto and Justice Debashis, a very elaborate discussion, and the person, the petitioner, the respondent therein was also serving for 27 years, and the court held that as per the scheme, since the scheme provides for 30 years of continuous service, and since the respondent has completed only 27 years of service, the benefits under the scheme is not applicable to this.
Lordship,
Just
yeah,
recently.
I'm grateful, Your Lordship. I'll get the judgment, Your Lordship.
Yes, a very elaborate discussion. So this court wants to. It doesn't mean that actually like we will be completely relying on that, but since there are some judgments, we just want to actually like wait.
I'm grateful, Your Lordship.
But actually, that judgment is just similar as yours.
Lordship.
Just similar as yours. They are also 27 years.
Lordship.
And so just see, just check. We'll give you time. Yes, and Mr. TV, anything more?
And then the judgment relied upon by the petitioner, Your Lordship. That is the judgment dated 8/7/2013, passed in WPC 213.
8/7.
8/7/2013.
2013 passed by
Passed in WPC number 213 of 2012.
WPC 213
Of
2012.
Page 42, Your Lordship may note down, page 42 of the appeal memo.
Page 42.
Appeal memo. The facts in that case and the present case, Your Lordship, these are totally
This judgment is not applicable.
Yes. Your facts are totally different, Your Lordship. Now, fourth ground, Your Lordship.
Yes, we do. I think regarding that, the observation made by the learned single judge
Lordship.
on the 2015 scheme,
Yes.
I think it's just a passing remark.
Lordship, when once the scheme.
Yeah, let us just read that again. Let us just read that
Lordship.
again.
Page 49.
Page 49.
Page 49. Ninth line from the bottom.
Yes, today we are. correct?
Today we are not hesitant to repeat that the rule of 30 years continuous service of skill, to repeat that as provided under the scheme is not workable, which is against the constitutional provision, specifically Article 14, 16, and 21, Your Worship. Now, in spite of this clear observation made by the learned single judge, Your Lordship, in fact, if this scheme is again meant to be enforced, Your Lordship, it may even amount to contempt, Your Lordship. There's something which the Honorable Court has said that it is violative of Article 14, 16, and 21, whether any further order necessary to say that, no, it is set aside. If it is unconstitutional, it is unconstitutional. If this Honorable Court says that it is violative of Article 14, 16, and 21, then it has to be so, Your Lordship.
But I do not find any definiteness in this observation.
I'll leave it to Your Lordship, but that is my humble submission, Your Lordship. As a matter of judicial propriety, Your Lordship, the department also should not now take recourse to this OM after this order, Your Lordship.
No, but Mr. Nchim, if you are also banking on 2015,
Lordship.
if you are banking on 2015, you should have filed counter appeal, at least against this observation.
Lordship.
You should have filed counter appeal.
Lordship, in fact, I'll come to that, Lordship. But before that, now the grounds taken by them, I have some clarification to make. You got to the CCS pension rules, Lordship. Because my learned friend has only read the portion which is his concern.
Are you over, Mr. TV? Are you over? Please, yes.
The fourth ground, Your Lordship, I have third ground. The
What
fourth
is your
ground,
third ground?
third ground is that the decision relied upon, page 42 of my appeal memo, decision relied upon, that is WPC 213 of 2012, order dated 8/7/2013, Your Lordship. This is not relevant because the facts are totally different. Now, fourth, Your Lordship, while passing this order, the learned single judge, fourth, Your Lordship,
Fourth ground?
the fourth one, Your Lordship, while passing this order,
Yes.
the learned single judge has relied on a decision passed by division bench of this court, State of Manipur versus Ibopal, that is
Which
read appeal number 102 and 103 of 1995, Your Worship.
read,
May I take
have you given a copy?
No, I have not given the copy, Your Worship. Page 51 of the judgment of the learned single judge. Page 51.
Page 51.
Which I
Just
read.
just wait.
Yes, the State of Manipur and others versus KSH Ibopal, which is reported in 1997 2 GLT 209, Your Worship.
Yeah, this is not
So,
applicable.
in
why?
my respectful submission, Your Lordship, this is no more a good law post Umadevi.
Why?
Yes, because post Umadi, yes, Your Lordship, para 53, Your Lordship, and why I'm coming, Your Lordship, if my Lord may kindly, if my Lord may kindly turn to my distinct compilation, I have annexed one decision, Your Lordship.
Yes, please.
I have also given the list of books also, which is reported in 2022 for GLT. Yes, yes. No, no, Your
2014
no,
5
no.
GLT.
No, Your Lordship. The second decision is 2014, Lordship.
2014 5, na?
5 GLT 729.
Para?
Para here, Your Lordship. In GLT, it will be para 4, Your Lordship. But I have downloaded from SEC online. Here it is para 3. My compilation. I'm referring to my compilation.
Okay.
Lordship. But in GLT, it will be para
Okay,
4.
we'll check out.
After rendering service for about 19 years in the said post, Lordship has got it.
Yes.
Without any break, the petitioner retired from service on superannuation with effect from 1/4/1995. As the appellant was not appointed on a regular employee against any sanctioned post, no pensionary benefit was given to him after retirement, Your Lordship. This is by division bench, Your Lordship, Tagatamjan, where my Lord appeared as additional AG, Your Lordship. In fact. Para 10 of my compilation, Your Lordship. Para 10 to my citation. Lordship has appeared. Now I'm relying on para 18. In GLT, it is para 16, Your Lordship. Para 18. There can be no dispute that in order to be entitled to get pensionary benefit, the employee must hold a permanent sanctioned post as a regular employee. This is in tune with para 53 of Umadevi, Your Lordship.
Yes.
So this is by division bench of this honorable court, Your Lordship, post Umadevi. So for pensionary benefit, Your Lordship, the employee must hold a permanent sanctioned post as a regular employee, Your Lordship. But in the present case, Your Lordship, the petitioner who was serving as work charge, Your Lordship, and he is also not covered under the scheme which has been framed for regularization of work charge and casual employees, Your Lordship. Now, fifth ground, Your Lordship. My fifth ground is, Your Lordship, even without challenge being made to the constitutional validity of the
Yes,
scheme,
please. Yes, please.
2015,
Yes,
Your
yes,
Lordship.
please. Yes, what is the fifth ground?
Lordship. Even without challenge being made to the scheme, Your Lordship, the same has been held to be violative of 14, 16, and 21, unconstitutional, Your Lordship. Sixthly, Your Lordship, the learned single judge has changed the status of the opposite party petitioner from work charge to contract. And last, Your Lordship,
Yes, please. From work charge to
to
contract.
contract. And last, Your Lordship, there's also delay and lectures on the part of the opposite party, Your Lordship. Delay and lectures because petitioner was released in 2014. Just I'll give the year, Your Lordship. Representative submitted in 2019 after 5 years. and petition filed in the year 2021, after 7 years.
Representation submitted?
2019. After 5 years, and then read petition before
2019 and read petition filed.
2021. Now, Your Lordship, unfortunately, Your Lordship, since estate could not file a detailed could not file affidavit, Your Lordship, all this aspect of the matter that he is not covered under the scheme, or he is not covered under the CCS pension rules, or that judgment relied upon by the petitioner is not applicable because facts are totally different. All these issues could not be brought by way of filing an affidavit. Your Lordship, at
No, but certainly this court can give you an opportunity to file an affidavit.
Lordship,
Yes.
subject to what my learned friend says, I'll be satisfied. Let the detailed affidavit be filed, liberty be given, and then let the petition be disposed of on merit, Your Lordship. After taking into consideration all this aspect, the ground, especially ground taken by the petitioner before the learned single judge, that he is covered under the CCS rules, not so. That he is covered under the scheme, not so, Your Lordship. The decision which has been relied upon by the petitioner, Your Lordship, that the facts are totally different, Your Lordship. Those, like, I'll be satisfied, Your Lordship. I need not sum up because I've already given those the 7 grounds which I've on which I am questioning the challenging the order.
Whether the impugned judgment has reflected anything on the non-filing of the affidavit? by
No,
the
Your
government?
Lordship, just instruction, on the basis of the instruction, the government advocate appeared, Your Lordship. She said that, only said that the case of the petitioner does not come within the purview of that OM because petitioner has not completed 30 years. Except for that, the other issue could not be taken up, Your Lordship.
Page 48, Lordship, of the appeal memo. The statement that the state respondent, they have instruction, and that's how a specific mention has been made. That I'm not covered under the scheme.
Mr. TB,
Lordship.
what would be the consequence? What would be the consequence if we allow you to file detailed affidavit in opposition in the appellate stage?
No,
Because normally in such a case, matters are remanded back.
Lordship,
Matters are remanded back.
Lordship.
But here is a case where actually now you are in appeal. And instead this court, we are just discussing, instead of remanding back, whether it'll be proper for us to allow you to file proper affidavit. Whether that would be proper, or if not, whether there'll be any consequence. Mr. Bharat.
Lordship, in that case, be it for the state respondent or for the petitioner, we will be losing a forum, Your Lordship. We'll be losing a forum. It may go either way, but then we'll be losing a forum. That is the thing. It may be against the petitioner, or it may be against the state. But then we'll be losing, whichever side, Your Lordship, we'll be losing a forum.
So what you mean is that it has to be, if opportunity is to be given to you, it has to be remanded back.
And to file an affidavit and then to dispose of on merit, Your Lordship, subject to what Your Lordship says.
Yes, that is of course.
Yes,
the
there are
right
certain
approach.
issues, many issues are there which has not been taken into consideration, Your Lordship.
That's why I was asking you whether any issue on the CCS pension rules has been decided.
Yes, that's it.
That has been in the judgment, which my learned friend has skipped. Because in the judgment of 213 of 2012, CCS pension rule is not applicable.
Lordship, we can continue after lunch, after break. Yes, come.
Just think over and come. We are also of the view that we will have to remand this back to the learned single judge.
Because
Because without affidavit, the state has actually without affidavit, this judgment has been passed. And we feel that the state should be given the opportunity to file proper affidavit and to contest the case. We are of that view.
Okay.
But will come, you assist the court also on that
Lordship,
issue.
Lordship.
Okay. Yes, brother. Yes, Mr. TB and Mr. Nchim, we are of the view that this matter has to be remanded back. We are of the view. And in that event, the judgment which is impugned will be set aside.
Lordship.
Because if there is any conflict on that, then we will have to pass an order directing the state to file affidavit. That's the only option before us.
Leave it to your Lordship.
Because our friend Mr. TB has raised so many grounds
Lordship.
which we do not find in the record.
Lordship.
Because, Lordship, though the CCS pension rule, which my learned friend has raised again and again, Lordship, the judgment that I have relied before the single bench, Lordship, the court has made observation that CCS pension is not applicable to me. And that observation was made by the single judge himself.
Not applicable to you.
Yes, and that has not been reflected in the order also. Because, Lordship, just for the
If what you are saying is true, then you have no more case.
no, after that,
Because 2015 scheme has been, you are not qualified under that
yes.
scheme.
Now, Lordship was mentioning about the judgment of this court. Now, there's a line where it has given Lordship. Paragraph 31 of the judgment which Lordship was referring to, Justice Serto and then Justice Devashish Bora, Lordship. We further make it clear that the office memorandum dated 22/9/2004. Lordship. Sorry, madam. We further make it clear that the office memorandum dated 22/9/2004, that is the first scheme, 50/50, Lordship, would also continue to be applicable insofar as the same is not inconsistent with the office of memorandum of 2015.
Read para 30.
30, Lordship, I've read, Lordship.
You ever read again? Let our friend also here.
Lordship. Basically, the 30 is on the facts of the case, Lordship. On the basis of the above finding, an important issue further arises for consideration as to whether the post which has fallen vacant in view of the setting aside of the appointment order of the respondent number 3 and 4, the appellant in the writ appeal number so and so are required to be taken in consideration for regularization of the service of the petitioner. The appellant in writ appeal number 15/2022 or the said posts are required to be filled up in terms of the direct recruitment by the NPSC. Clause 1(2) of the office memorandum 15 stipulates that it is applicable to those work charge and casual employees who have completed or will complete 30 years of continuous service after 1/1/2015, meaning thereby the right of the petitioner writ appellant to be regularized would only arise after they render 30 years of continuous service. Now, but they have made again a clarification. Since 2015 is not consistent, so 2004 will apply.
No, that is a different issue. But so far as this case is concerned,
Lordship.
the appellant or the appellant therein
Yes.
had worked only for 27, 28 years.
Yes. Now,
And his case was that he is entitled to be regularized under the scheme.
yes,
That is the observation of the
Yes.
Honorable Division Bench.
they are in service.
So we cannot go beyond that.
Yes, because this petitioner and the respondent, they are in service. They are in service. Still serving.
They are in
But
service.
our case is we have retired, Lordship. Now, the judgment that we have relied upon, Lordship, that my learned friend has relied, that 213 of 2012 judgment. This Honorable Division Bench, I have placed for your Lordship also.
That is by Justice
Ujjal Bhuyan and Honorable Justice Manojit Bhuyan. They have upheld the judgment, the 213, without considering that CCS pension rules. And my learned friend has been, again, banking on the Uma Devi case, Lordship. The ratio has been laid down. In the Union of India versus the Central Acquisition Tribunal case, Lordship, which I have already placed, Lordship.
Okay, let us give proper opportunity to the government.
Yes, I have not placed, Lordship, sir. It's
Okay.
just a small paragraph, yes.
We'll give a proper opportunity to the government because it will also not be proper for us to decide a case without any affidavit of the government.
Yes, exactly, Lordship. In fact, Lordship, since it was my case, Lordship, it is my case. I made a submission. Without an affidavit of the government, it will not be proper for the court to pass an order. Because there is a question of regularization of service. So the government sought for time. The court, taking account that so many opportunity has been given, will hear a matter. And the government advocate agreed, Lordship. So as per the instruction received by her, because she brought that instruction, the government advocate, on that particular day, that she has received instruction, she'll be filing affidavit, which I did not object. Because as a counsel, Lordship, I know the consequences. If no affidavit is filed, Lordship, just basing on the writ petition, the case cannot be decided, Lordship. If it's a case of consideration of the representation, any filed by the party's Lordship, then that aspect too, we understand, Lordship. But here's to decide the fate of an employee for grant of pension benefit. And without affidavit, I felt it necessary that the government should file an affidavit, Lordship. Anyway, Lordship,
But
little
Mr.
discussion of court.
T.B. Jamir, the learned counsel for the appellant, and Mr. N. Muzui,
Opposite party petitioner.
the learned counsel for the
Sole opposite party, Lordship.
sole opposite party, sole opposite party. Stop. This case was taken up for hearing. Stop. However, in the course of hearing, it was noticed from the records that no affidavit in opposition was filed by the state while deciding the writ petition.
Lordship.
Stop. On inquiry from the learned counsels representing the case as to whether any affidavit in opposition was filed by the state in the writ court, both the learned counsel for the parties stated that no affidavit had been filed by the state government. Mr. T.P. Jamir, the learned counsel for the appellant, has challenged the
Lordship, since
order dated 18/11/2022 passed by the learned single judge on various grounds. Stop. However, without there being any proper affidavit filed before the writ court, we find that it may not be proper for us to deal with all the grounds raised in the present appeal. We are therefore of the view that the present writ petition number 215,
Lordship,
215 K 2021 has to be remanded back to the learned single judge. Has to be remanded back to the learned single court, single bench, and allow the state respondents to file necessary affidavit in opposition and to contest the case on merit. Stop. We therefore direct WPC 215K 2021 to be listed before the learned single judge.
Lordship, be restored to file and be listed.
Cancel the last line, the writ petition WPC 215 K of 2021 be restored to file and be listed before the learned single judge.
Lordship.
The judgment and order dated, is it judgment and order?
The order, Your Lordship.
Is order, Lordship.
The order dated 18/11/2021
Lordship.
passed by the learned single judge in WPC 215/2021 shall accordingly be quashed and set aside.
Lordship. Lordship.
Stop. Parties to appear before the learned single judge.
Lordship.
Lordship, a time frame may be given to the state to file the affidavit, Lordship.
Pardon?
A time frame to be given to the state to file the affidavit, because I have to file reply to that also, Lordship. Because since the petitioner has already retired, Lordship, is an old
Your
man,
Lordship,
Lordship.
since the matter is pending for long, it may be disposed of expeditiously.
Within a time frame, Lordship. If time frame can be given for disposal of the repetition, Lordship.
When is the matter pending?
2021.
2021. It's a 2021 case.
Lordship.
We request the learned single judge to dispose the case as expeditiously as possible.
Lordship.
Well, what is this WPC 22? What is this IA?
Lordship, IU was for stay, Your Lordship.
Stay.
In view of this in IA, okay? IA. In view of the order passed in WA 26, 2022, the IA 125 of 2022 stands closed.
Lordship.
Lordship.
Much obliged.
Obliged, Lordship.
Okay.